Hi, I'm Lucas, and I've been part of the real estate agent for quite some time now. I'm happy to help you out with whatever you need.
Cool. Thanks for taking the time to talk to me. I just had a few questions. I'm starting out as an agent. So I was just wondering a few things about the regulations on the whole agency process, if you do have the time to ask the questions.
Sure, cool.
So firstly, what are sort of the rules you have to go through when you're trying to engage a vendor client?
So for your first point of call when you're working as a real estate agent, you really want to make sure that you're abiding to all the rules by the Real Estate Agents Act of 2008 and also the Professional Conduct and Client rules from 2012, just for an extra add-on. When you're engaging with a client, the first point of call has to be an agency agreement. So this is really just an agreement between both parties to say, yes, you are okay to work together on the sale. This agreement just has to have little basic information about all the different parts of your contract that have to be abided by. Just things like the sort of asking price, names of each parties, and so on. This can be cancelled up to 5 p.m. on the next working day, and then if not, then 90 days after this has taken place. This agency agreement has to be in writing, and both parties have to sign for it. When you're working with residential houses, the agency agreement can only be signed if and only if you've given the seller, the buyer, an information pack on the house itself.
So how do the rules and regulations differ when you're actually taking the property to market?
First of all information has to be shown to the client. There can't be any false advertisement at all, and anything about the property of any significance has to be adhered to. An example of this is a case where Rosa Tondi, who was a real estate agent, failed to tell a potential buyer that the house she was selling came back with a positive meth report, and therefore she was found to have unsatisfactory conduct, which is definitely something that you will not want to have in your time, as you can be fined heavily, and in some cases even stripped of being a real estate agent. You must also make sure you have the right title information, because if a house isn't under someone's name and they're trying to sell it, this will also be misconduct.
And so how about when you're receiving offers from purchasers who actually want to buy the property?
A licensee must act in good faith to all parties inside of the agreement, and must also show all offers to their clients. An example of this was in May 2018. John Misa had a potential buyer on the phone, but did not put his bid up in the auction.
So once you've found a purchaser, how does the entry into the actual agreement of the sale and purchase of the house work?
So the main point that you have to understand is that when you're getting into the agreement, the buying party and also the selling party have to have full knowledge, and so you should tell them to get some legal advice on if this is a good purchase or if it's not.
And what about the timings and all the other rules of the actual deposit in terms of paying it and all that?
So when the deposit is paid after the agreement is made, then you as an agent will hold the money in a trust account. And unless there are any disputes, then after that 10 working days, then you're able to release it to the seller.
And the last thing is just obviously the settlement of the property. Are there any other things to note there?
Yeah, so in the Property Law Act, so a bit different from the Real Estate Agents Act, this just says that the agreement has to be in writing and both parties must sign it.
Okay, so I think that should be everything. Thank you so much for your time and for this brief introduction into agency and all that. It was nice to meet you.
You too. No worries. Here's my business card. Email me and I'll send you through some information extra about just some different links about where you can learn a bit more.